On debate, Senator Simons.
Thank you, Madam Speaker. I too rise today to speak to Bill S-12, an act to amend the Criminal Code, the Sex Offenders Information Registration Act, and the International Transfer of Offenders Act. But I want to start at the beginning with how we got here, and a caution, some of these stories may be disturbing. In March of 2011, 19-year-old Eugene Lovu, an immigrant from Zimbabwe and a student at the Northern Alberta Institute of Technology, was invited by a female friend to a Jersey Shore-themed party in Edmonton. The party was billed as a DTF event. That stands for Down to Fraternize, except the F word used in the advertising was not fraternize. Lovu said he didn't want to go, that he had too much to do the next day. But the friend insisted on his attendance and told him he could stay overnight and that she would arrange a ride to work for him in the morning. Once at the party, Lovu started to drink with the woman who'd invited him and another mutual female friend. According to the agreed statement of facts, the teenager touched the second girl on her buttock and thighs. Later the next morning, the first girl, the one who'd invited him, woke up and found him trying to put his fingers inside her. She told him no. He tried to convince her. She said no again, so he stopped and left. He was subsequently charged with 2 counts of sexual assault. The first count for attempting to put his fingers inside the first woman's vagina, and the second for touching the other friend's bottom and leg without her permission. The young man, who had no criminal record, pleaded guilty to 2 counts of sexual assault and was sentenced to 6 months. Those convictions should have put him automatically on the Sex Offenders Registry for life, with all the onerous and humiliating consequences that would entail. But the trial judge in Edmonton, Madam Justice Andrea Moan, exercised her common sense and determined that placing the young man on the registry in such circumstances was unwarranted, given that he had taken responsibility for his actions and shown great remorse. She also noticed that placement on the registry might make him especially vulnerable to racial profiling. Quote, "The law as it stands now will place Mr. Ndlovu on police radar for the rest of his life, anytime a sexual offense is committed by a black man of average height in his neighborhood," she said. She added that putting his name on the registry would, quote, "bear no connection to the object of assisting police officers in the investigation or prevention of further sex crimes." This seems to me to have been a logical use of judicial discretion. The sexual assault on the one woman was serious enough that it led to jail time. But the second charge, the one that involved touching the second young woman on the bum and leg, was surely less so. Indeed, I think one might legitimately wonder if there was some pressure on the Crown to charge Ndlovu with 2 separate offenses, simply for the sake of putting him on the registry, especially since inclusion on the registry only became automatic in April of 2011, less than a month after the assaults took place. The Crown appealed and won a split decision at its Court of Appeal in Alberta. It was, let me note, though, Madam Justice Ritu Kular, who is now Alberta's Chief Justice, who dissented and supported the ruling of the original trial judge. The split decision helped to allow for a Supreme Court appeal. And in October of 2022, Canada's Supreme Court, in its own split decision, upheld the trial judge's original ruling and deemed the mandatory automatic placement of sex offenders on the National Registry unconstitutional. As we've heard, the court gave the government 1 year to come up with a response. So now we have Bill S-12 and the political imperative to pass the bill before the clock runs down. Under the terms of the legislation, inclusion on the Sex Offender Registry will still be automatic for repeat offenders or those who commit sex crimes against children. But in all other cases, the defendant will have the right to challenge the registration. If the offender can demonstrate that being put on the registry would be a disproportionate to the offense, then the judge can opt not to include them. As Senator Bussin has just explained, the onus is reversed, and the default is to be on the list unless you can make the case that you shouldn't be there. Then the judge will decide whether being placed on the registry is warranted, paying attention to factors including the nature and seriousness of the crime, the victim's age and other personal characteristics, the nature of the relationship between the victim and the perpetrator, the accused's own circumstances, whether or not the perpetrator has a criminal history, and the opinions of expert witnesses. So under Bill S-12, judges will at least be given back some of the autonomy and responsibility for passing judgment. Having heard all the trial testimony, they will then decide whether placement on the registry makes sense in a particular case, whether it's proportionate, whether such registration will protect public safety while respecting the rights of the defendant. There are certainly those who would argue that the whole idea of a sex offender registry is counterproductive, that such a blacklist is a crude American import that has no place in Canadian society. And one could certainly make an argument that these lists are a kind of security theater, which do little to protect the public or reduce recidivism, but that they stoke public fears and public hysteria while making it harder for those who have served their sentences to reintegrate into the community and stay out of trouble. In the words of the Supreme Court itself, quote, despite its long existence, there is little or no concrete evidence of the extent to which these lists assist police in the prevention and the investigation of sex offenses. And there are certainly those who would say that the reverse onus tests puts an unfair burden on defendants, reversing the balance of our criminal justice system, which gives the state, the Crown, the legal burden of making its case. Yet from a political perspective, I can understand why the government might hesitate to abolish these problematic registries and is instead taking this far more modest step to comply with the Supreme Court's direction. Still, once this bill is in committee, I hope hard questions will be asked about the value of sex offender registries at all, whether they are whether they are merely counterproductive political show. The legislation before us also represents a fundamental and long overdue shift in the way we disempower and shame victims of sexual assault. For too long, Canadian courts have slapped automatic publication bans on the names of sexual assault victims without considering whether such bans are always in the interests of individual victims. The practice that began almost 40 years ago started as a noble one. The idea of so-called rape shield laws was to protect sexual assault victims from public shame and public scrutiny, to encourage them to come forward with charges by protecting their identity. But sometimes victims want to be known. They don't necessarily want to be protected in perpetuity in a way that infantilizes them and robs them of agency and self-determination. Let me give you an example of what I mean, a case I wrote about back in my own days as a journalist. In 2006, the kidnapping of a 10-year-old Saskatchewan boy shocked and horrified the country. The child had been snatched from his parents' home in Whitewood, Saskatchewan, by notorious serial sex predator Peter Whitmore. Whitmore took the boy to an abandoned farmhouse near Kipling, where he'd been holding another prisoner, a 14-year-old boy he'd abducted weeks earlier. The 10-year-old was rescued after 2 days, thanks to an alert farmer who noticed signs that someone was living in the abandoned house. The boy had been chained to a bed, forced to walk around naked while wearing a dog leash. Even after Whitmore was convicted, the boy's trials didn't end. He was so bullied in his small-town school, where the other kids called him horrible homophobic names because of the sexual assault, his parents finally had to withdraw him to homeschool him. At the time of his abduction, his name and photograph were everywhere. But once the trial began, the court imposed a publication ban on his identity, and it became a criminal offense for any media outlet to print his name or picture. And a decade later, it was still illegal for him to blog or post to Facebook about what he'd endured. The whole country knew the ghoulish details of his abduction, yet he himself was forbidden to talk about how he had survived, to share his story, to work through his pain. Then, in late 2015, a Regina court finally gave to Zachary Miller his name and his voice. Justice Catherine Dawson of the Saskatchewan Court of Queen's Bench granted Miller's application to lift the ban. Miller had argued that he wanted to be known as a survivor, not a victim, that he wanted his story to help others coping with the aftermath of abuse. Quote, I feel a victim under this court's publication ban because it has refused me the right to use my name in any form of media, which in a way has refused my rights of freedom of speech, testified Miller, who was then 20. So you may say, well, if victims can challenge bans, even if it's expensive and time-consuming, why do we need Bill S-12? Well, it's because victory isn't assured. Take another case I wrote about, the story of a young man from the St. Paul area of Alberta who had a sexual relationship with a female teacher when he was just 17. The teacher, who'd insisted the sex was consensual, was eventually acquitted of sexual exploitation. And in 2007, 7 years after the trial, the young man, who was then 26, applied to have the publication ban lifted so he could finally speak out about the lasting psychological pain of being victimized by an adult he had trusted. The Crown, to its credit, did not oppose the application, so you'd think this would have been easy. But the justice in the case refused to lift the ban, ruling that doing so years later would not be in the public interest. The man's only option was an appeal to the Supreme Court of Canada, He did so, but the court declined to hear his case. Thus misapplied, the almost unliftable publication ban re-victimizes victims in the name of protecting their privacy. It's patronizing and paternalistic. Worse, it sends sexual assault survivors the explicit message that they themselves have been so shamed and dishonored that what's happened to them is so peculiarly and uniquely disgraceful that they must be hidden away from public view. It's a medieval attitude to rape informed by misogyny and homophobia, and it belongs in our past. So Bill S-12 goes some way to righting the balance. It says a victim must be consulted before a publication ban is imposed. It also says a court must hold a hearing for any sexual assault victim who wishes to revoke or vary their own publication ban. But this is, again, a compromise. The request is not granted automatically. The bill says the court may consider any material change in circumstances, including the victim's wishes, but ultimately the court must rule not based on what the victim wants, but on whether lifting or varying the ban is, quote, in the interests of justice. And while the bill goes some way to re-empowering those victims who choose to speak, it also includes broader provisions to protect the privacy of those who do not wish to have their identities known. The existing law bans the publication or broadcasting of any information that would serve to identify a sexual assault victim. In this social media age, Bill S-12 widens that provision to include anyone who transmits or otherwise makes available information about any victim, witness, or justice system participant whose identity is protected by a publication ban, a provision that would seem to cover tweets, toots, Facebook posts, or even group chat gossip. I'm sure this, too, will be an issue of much debate in committee, since it would potentially open up to sanction not just newspaper publishers and television stations, but lots and lots of ordinary citizens. Because of the Supreme Court deadline, we are under some pressure to pass this law quickly, and yet I hope we will allow ourselves the necessary time to study its complexities and its contradictions, because these are vitally important issues that speak to our civil liberties and the safety of our communities. Thank you, merci, and hi-hi.